started coming towards me, and then he lunged at me. I held the gun.
I had to take my shirt.
Okay.
And she was bleeding her nose and her mouth and her ears.
Based on these serious allegations, and I will note, this case will be transferred to common pleas.
The former ballerina charged in the death of her husband testified, presenting her side of the story in what's being dubbed the Black Swan murder trial. On the fourth day of the trial, Ashley Benfield took the stand, claiming her husband, Doug Benfield, was not who she thought he was. She recounted the moments leading up to her pulling the trigger, stating that on that day, she shot and killed her estranged husband. Ashley Benfield testified that despite their separation, Doug Benfield was at her home helping her pack for her planned move to Maryland. She claimed that Doug became aggressive, causing scratches on her body. Ashley stated that Doug then hit her on the side of her head and refused to leave her home, starting to threaten her. In fear, Ashley Benfield said she ran to her room and grabbed her gun. She described seeing Doug in the doorway with black eyes and veins bulging from his neck before she fired the fatal shot.
Started coming towards me, and then he lunged at me. I held the gun in front of me, and I said, "Stop." And he turned and he got into this a fighting stance. I got low. He started moving his arms and his hands around. And he was making these jerking motions.
Ashley Benfield was visibly shaking during parts of her testimony as she stated she shot Doug because she feared for her life. She also testified that Doug admitted to abusing their pets and had even fired a gun inside their home. The defense read texts that Doug had sent to Ashley within the first month of their relationship, which included a message saying, "You haven't seen the warrior side and never want to."
We went from joy and passion to now I'm in a testosterone rage inside.
Prosecutors challenged Ashley Benfield's claims of domestic abuse, asking why she would want to have a baby with an abusive partner. They also presented videos and pictures of the couple, alleging they enjoyed each other's company.
Are you scared here of Doug?
No, I would not say.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Okay. Were you living the nightmare here?
Oh, no, not at that moment, no. That was a very nice day.
How about at this moment?
Oh, it was a good day.
And States 102 at this moment?
Same. It was a good day.
During cross-examination, Ashley Benfield admitted that Doug never punched or kicked her. The state continued to portray Doug as a protective spouse and Ashley as a jealous stepmom, asserting that she wanted sole custody of their daughter and would do anything to achieve that. Christopher Dunn is preparing to leave prison after spending decades behind bars for a murder he has long insisted he did not commit, after serving 33 years, more than half his life. Dunn's family eagerly awaits his release and the beginning of a new chapter. 2 months ago, Dunn's friends testified in the courtroom. One friend stated it was too dark to identify the shooter on the night of the 1990 incident, while another woman testified that she was on the phone with Dunn when the shooting occurred, making it impossible for him to have been the shooter. Their testimonies have played a crucial role in Dunn's potential release. Curie Donna, nearly speechless, is overjoyed that her husband is finally close to gaining his freedom after 3 decades behind bars.
I have no words. I'm still processing this. I'm so thankful, though. I can tell you that I'm so thankful that we're all still.
Exactly 2 months after the testimony concluded in the same courtroom, a judge ruled that Chris Dunn must be released. In 1991, a St. Louis court convicted Dunn of killing Rico Rogers on a dark spring night. 2 young boys initially claimed Dunn pulled the trigger, but later admitted they lied. Another boy, who was with Dunn that night, testified in Dunn's defense.
The thing I saw was the fire coming from the gun.
Another friend also vouched for Dunn's defense.
I had to tell them then that he couldn't have been there. I was on the phone with him.
But Dunn's freedom isn't guaranteed yet.
We saw with the Attorney General's office, they tried their best to delay Sandra Hemi's freedom, but she eventually got out. Is that a concern for you all as well?
Well, yes, it is. We were watching that happen for Sandra and her family, and we were fearing that the same would happen for Chris.
Curie could be just hours, days, or weeks away from being reunited with her husband.
Never give up on trying to help the person you love.
It's sentencing day for a man who shot and nearly killed a Suffolk County police officer, leaving him partially paralyzed. Janelle Funderburk will spend 25 years of life behind bars. Suffolk County police officer Michael LaFosse entered the courtroom with the assistance of a cane, accompanied by his pregnant wife, who is expecting their second child.
To say that I can't play with my daughter. I have to tell her, I'm sorry, Daddy can't pick you up today, because Daddy's not physically able to. Yeah. That's all.
He is not physically able to fully recover because a bullet fired by 21-year-old Janelle Funderburk nearly killed the 6-year member of the department.
Hitting a vital area. It's by God's graces, by the officer's actions at the scene, that he's with us today. And he's not more disabled than he is.
The halls were packed with police, many of whom had stood by LaFosse's hospital bed. LaFosse told Funderburk, "I was just trying to do my job, but you were trying to kill me," and stated that he would never forgive him. Officials argue that the career criminal, who had been charged 7 times before he was 18, should have never been on the street.
This defendant was arrested 1 month before the shooting. He should have been in jail.
The message is, if you attempt to kill a cop in Suffolk County, you will meet with the harshest of penalties, and you will forfeit the better part of your own life.
When given the opportunity to speak, Funderburk expressed his remorse. In a statement read by a friend, his mother said she hopes to bring awareness to the mental health crisis and the opioid epidemic.
Son is schizophrenic and has an opiate addiction. She feels she has failed him and the bail reinforcement.
Funderburk's attorney argued that it was the system that failed him.
His father is in jail, his brothers are in jail. There were red flags all along that there were issues with him. And they weren't addressed.
LaFosse's leg is partially paralyzed, and he attends physical therapy twice a week. Doctors hope that some of the nerves can regenerate over time. As for Funderburk, the judge declared him a menace to society before sentencing him to 25 years to life, adding that he would impose an even longer sentence if it were up to him. Prosecutors in juvenile court announced that they will request to try 2 teens charged with the murder of 29-year-old Alexa Stakely as adults.
So far, what we're seeing just from the preliminary report seems to display a level of callousness about the victim's life.
Stakely, a young mother, was killed on July 11th after being thrown from her car while it was being stolen with her young son in the back seat. Just days after police released photos of 3 suspects, a boy and his parents showed up at police headquarters. The teen admitted that he and 2 acquaintances were looking to steal a car in southeast Columbus when they found Stakely's car running in a parking lot. Investigators say the teen confessed to stealing the car and panicking, which led to striking Stakely. 2 other suspects, who police say were present when the car was stolen, were also in custody.
On these serious allegations, and I will note this case will be transferred to common pleas.
19-year-old Gerald Dowling Jr., the only adult charged in the case, is being held on a $10 million bond. Dowling did not appear in court for the charges. Both teens attended Canal Winchester schools, where Stakely was a speech pathologist. The juveniles also did not appear in juvenile court. It has been learned that the 2, who had no previous records, are ordered to remain locked up in the County Juvenile Intervention Center. With his mother and family by his side, Damian Redmond watched as the man accused of killing his father, 65-year-old James Redmond, once again stood before a judge. Damian described his father as a hard-working man who loved his family.
If you came across him, he was very nice, very humble, hard-working, loving, caring.
Police say Richard Lewis shot and killed James Redmond at the main event following an argument about the use of metal detectors. Both men were working as security guards, but the state of Tennessee confirmed that Lewis was the only one not licensed for armed security.
And to find out that this guy working and shooting in a business like that with kids with no license.
Lewis was scheduled for a bond hearing, but waived it after prosecutors presented surveillance video of the killing. Redmond's attorney stated that they waived the hearing to gather more data. While the video was not shown publicly, Redmond's family was privately shown the video before the hearing.
It was senseless. He didn't try to do anything to him. He was your boss. He was your supervisor. He was just telling you.
Redmond's family says that Redmond and Lewis had worked together for years and that Redmond was Lewis's superior.
We know him personally.
We know him personally,
it's not somebody that's a stranger to us, you see what I'm saying? My dad and took him home.
It was just shocking that Lewis did something like that.
Damian says that his family plans to attend every court hearing until they get justice for his father.
Don't have no self-control. conscience or common sense for what he did. I mean, I wouldn't let nobody like that out of jail, you see what I'm saying? As far as the community, I feel like he's a danger to the community.
A Grant County man walked out of his own court hearing while a jury was deciding his fate on multiple charges. Joey Watts, who was on trial for aggravated assault and possession of a firearm, simply walked out during the jury's deliberation. Watts was seen sitting next to his attorney in court, awaiting the jury's verdict. Suddenly, he got up and walked away. Security footage captured him walking down the hall, descending the stairs, saying something to his family, and then exiting the building.
It's one of them crazy deals.
He was last seen walking down the street and then disappearing, all while the jury was still in court. Grant County Sheriff's Office Chief Deputy Pete Roberts explained that Watts was out on bond, which allowed him the freedom to move around.
Mainly the fact that he was not in custody, he wasn't, an inmate or anything, that allowed him the freedom to move around throughout the courthouse and things like that.
Roberts mentioned that there wasn't a second bailiff in the courtroom because they simply didn't have one.
The circuit court's in the process of hiring a new bailiff to prevent that, but they haven't got that done yet.
Deputies apprehended Watts less than 24 hours later. Roberts stated that 3 others are now facing charges for aiding him in his escape, and he believes there will be more arrests to come.
Clear that anybody that helped him is now facing Class C felony charges also.
While Watts was on the run, the jury ultimately found him guilty of his charges. A mail carrier is under fire. She is accused of going on a shopping spree using credit card information she stole from dozens of people along her mail route. Ashley Williams, the mail carrier, was initially charged with mail theft and credit card abuse of an elderly person. However, those charges have since been upgraded. Williams allegedly stole over $220,000 from residents and businesses in Woodlands Heights, including checks, credit cards, and debit cards. One of these credit card thefts was caught on camera.
I threw her package on the porch.
This is Ashley Williams in 2021, working on the same route where investigators say she stole from over 50 victims. One of those victims is Sandy Elizondo.
3 cards total, and altogether it was probably about 3,000, maybe 3,500.
And these are cards that you had ordered for yourself?
Right.
Or for your mom?
Yeah.
Elizondo was one of many who began to see fraudulent charges pile up. She believes more than just her debit cards were taken.
2021, when I got laid off, when I finally went to file for unemployment, they told me there was already an active claim. And it was not me, so I was like, it's not me, so there was some type of fraud. It had to be her.
Williams was in court. Prosecutors believe her crime spree began in 2019. According to court records, Williams was found with 47 mail parcels in her car, all belonging to other people during her arrest.
After the investigation, it was discovered that over $220,000 in checks that were destined for businesses in that zip code had been stolen and wound up in the bank account of this defendant. Over $150,000 of that was sent to go to nonprofits, churches, centers that work with mentally disabled adults. So the 3 new charges that we filed indicted yesterday were the aggregate theft from nonprofit, over $150K, the theft of essentially everything that wasn't a nonprofit, which was in a 3rd-degree felony range, $30 to $150K, and then a fraudulent use of identifying information.
Williams's bond was set at $75,000, an amount she has since posted. 2 South Florida men suspected of stealing mail have been arrested in St. Johns County. The sheriff's office reported finding incriminating evidence in their cars after pulling the men over. Several residents mentioned that mail they dropped off at a nearby post office never reached its destination. According to the sheriff's office, deputies made contact with the 2 suspects, who then sped away. The St. Johns County Sheriff's Office used a pit maneuver to stop and arrest 28-year-old Darren Simmons from Miami and 27-year-old Anthony Camp from Hollywood, Florida. Inside the car, deputies found stolen mail in a trash bag, a gun, a stolen mailbox master key, a mask, and gloves. One local resident who wished to remain anonymous reported multiple checks stolen from the Fruit Cove post office in November and December, including a $15,000 check that was fraudulently cashed. Simmons and Camp are both charged with felony possession of personal information found inside the stolen mail envelopes. The Postal Service Inspector General informed U.S. House Oversight Subcommittee members that mail theft is becoming a growing problem.
We've seen situations where groups of organized
criminals are working together to recruit postal employees to steal from the mail and other things. So it's become a bigger and bigger deal, and these cases have become much more complex than they used to be.
A former Jacksonville postal worker pleaded guilty to stealing mail. Additionally, at least 3 Northeast Florida postal workers were robbed at gunpoint, including one whose master key was stolen. For residents like Bill Gates, the reports of missing mail and violence against postal workers are deeply concerning.
It's certainly alarming, but I think that, the post office, obviously someone did a good job of tracking it down pretty quickly.
The St. Johns County Sheriff's Office says it collaborates with the U.S. Postal Inspection Service. A builder has been arrested and charged with embezzlement, grand larceny, and fraud. New lawsuits have been filed against Spencer Calvert, who investigators say abandoned several projects in Nocatee, pocketing over $15 million in deposits from customers. Calvert, the president of the Pineapple Corporation, was taken into custody last week on felony charges. 9 homeowners are now suing him personally for the money they lost. Instead of a jury trial for these lawsuits, Calvert is seeking to settle the cases through arbitration. The state of the homes that were left behind can be seen. One has been sitting unfinished for about a year, according to the homeowner, who is one of those filing a lawsuit against Calvert. This is part of their effort to recover some of their money. This neighborhood illustrates what happened when homeowners contracted the Pineapple Corporation for their custom Nocatee home builds. Some homes were finished, while others weren't even started. Now, the company owner, Spencer Calvert, is being sued by 9 of his customers.
$15 million here that's unaccounted for. Are you guys looking into where that money went?
So, I'm not in it to comment on the criminal case and the allegations in the criminal case. Obviously, our goal is to recover as much of the money that was lost from our homeowners as possible.
James Gonzalez is the attorney representing the 9 homeowners left behind by Spencer Calvert. Calvert's attorney has filed a motion to move these cases to arbitration instead of trial, which Gonzalez explains is standard procedure.
So in the construction, in a majority of the construction contracts that you enter into, whether it's a remodel or a new home build, the contracts, it's fairly standard for the contract to have an arbitration provision in it, which simply means that if you have a dispute with your builder, or if the builder has a dispute with the homeowner, then rather than it getting handled in court, it gets handled in arbitration.
Copies of the contracts show that most homeowners signed despite the arbitration clause. However, Calvert did not honor numerous provisions in the contract, including the stipulation that construction would be completed by the end of 2023.
So there's a hearing to be determined.
And what's going to happen at that hearing?
And we'll discuss whether or not it's proper to have the claims against Spencer Calvert individually handled in arbitration or handled in court.
Several homeowners are taking legal action against Calvert. Most of them preferred not to talk on camera, but they expressed their gratitude to the state attorney's office and St. Johns County Police for taking their claims seriously and arresting Calvert. Everything revolves around Todd Kendhammer in this incident. On September 16, 2016, in La Crosse, Wisconsin, Todd's 911 call reported a car accident that led to his wife's hospitalization and subsequent death. Initially ruled an accident, further investigation led to Todd's arrest for Barbara's homicide. Lawyers for both sides present the same story from different perspectives. No one is guilty until the court hears both sides and decides based on evidence. Therefore, the court must listen to both sides equally.
What he saw was his wife flailing about violent. Arms, legs, shoulders, flailing about. He got out of the automobile, which was difficult because it was backed into the ditch. And he came around to the passenger side, and he opened the door to the passenger side, and the door kept closing on him. And he knew that he had to get her out of the automobile. He saw her flailing around, and he pulled the pipe out. And you'll hear that when he pulled the pipe out from the passenger side, with the door open behind him, as he pulled it out, the windshield became a fulcrum and caused another crack in the windshield. And when he pulled it out, he threw it into the grass. And you've seen a photograph of that pipe in the grass. And then he tried to get her out of the automobile. And it was extraordinarily difficult. He knew that she was stuck on something. He wrapped his arms around her and tried to pull her out, and he caught on something, and he yanked, and they tumbled backwards into the berm with her on top of him, which is how her head came to be next to the wheel. And he began, because he saw that she didn't seem to be breathing, he began to give her CPR. Now, you're going to hear from experts in this case that when she was struck in the head by the pipe, it was a critical blow, causing brain damage. And that additionally, she experienced, in the dynamic situation that was occurring in the car, she experienced what's, in layman's terms, the beginning of a cutoff of the air passage. And when they fell out of the car, he saw that she wasn't breathing and began to give her chest compressions. And then he thought, I have to call 911. And he was so overwrought that the first thing he did was call 191. And when the call didn't go through, he called 911. And you will hear those calls in just a moment. What you will hear in those calls is genuine distress. And you will also hear a moment in the calls when Mr. Kendhammer realizes that he has to reposition her because her head is facing downhill. And he has to get her head up the incline. And you will hear him say to the 911 operator, I'm going to try to do something with her. I'm going to put the phone down.
Dispatch, Jared.
Hi, Jared. This is Lisa over at 911.
Yeah.
Were you guys recontacting on that PI accident on Bergam Cooley? Or do you want me to try to?
I don't think so. Were you guys going to call that Bergam Cooley number? Not at this moment, no.
Okay, I'll try to recount it. I didn't want to do it if you guys were trying to get through. All right.
Okay. Thanks. Bye.
Hello? Oh, hi, this is the 911 center. You called me. I've got yes, hang on. I've got police and ambulance, first responders headed to Emming, Bergen Cooley. I need you to tell me what happened. Slow down. Did the car work? Need help. Okay. And so your wife is injured? Yes. Okay. And there was in a car accident?
Yes, a pipe or something came through her windshield. A pipe did.
Pipe? Okay. All right. And I'm going to connect you to medical information, sir. What's your first name?
Todd.
Todd, okay. And they're going to help her until somebody gets there, okay? And then you're going to hear a dial tone in the phone ring. Just stay on the phone. Let me talk first and they pick up, okay? Hi, this is Lisa 911. I've got Todd on the line reference that accident at Bergen Cooley in County M. He said a pipe or something came through the windshield and hit his wife. His callback number is the number on the header, 608-790-2360. So he needs some help with it. Go ahead.
Okay, tell me exactly what happened. They got her and she's hitting her head in the throat, I think, in the throat or something. She got coming out of her nose and mouth and it's really big and blue. How old is she? 46. Is she awake? No, I can't get her to run. She talked at first a little bit. Okay, is she breathing? No, I don't think so. No.
All right, sir. We do have help on the way. Stay on the line.
How long?
You're in.
Off the road.
Sir, I want you to stay. I want you to stay right where you're at, sir.
I'm going to try to do something with it.
Yep, we're going to...
I'm going to put the phone down.
I'm going to... Can you get her out of the vehicle, sir?
I got her out.
Okay, I want you to lay her flat on the ground.
I got her flat. I'm okay, Dave, but I don't know what to do with this.
Okay, listen carefully. I'm going to tell you how to do chest compressions. Place the heel of your hand on her breastbone, right between her nipples.
I know how to do that.
The other hand is top.
I know how to do that.
Pump the chest hard and fast.
He got blood coming out of his mouth.
That's okay. Go ahead and pump it twice per second and 2 inches deep, okay?
Okay.
Let the chest come up all the way between the pumps.
I'll come back in a minute.
Okay, keep going, sir.
Bubbling out of her mouth.
That's okay. That's okay. We're going to keep pumping the chest hard and fast, okay?
Pass out.
I'm very doing great. You're doing just fine. Keep pumping the chest hard and fast, 2 inches deep. Keep going, sir. You're doing great.
When the police noted scratches on your neck, you first said that was from working with glass, correct?
I said that, yes.
You don't work with glass at Crown, do you?
No.
And you work with windshields, but that's not the same as working with broken glass, right? I assume when you install windshields, you're not getting scratched up from broken glass.
It depends how bad it's broken.
Well, were these scratches from glass?
No, not from glass doing at home.
You said it was from working with glass.
Correct, I said that.
That was a lie.
It wasn't a lie.
It was not true.
It was not true.
Scratches were from her trying to get you off of her, weren't they?
Nope.
The two of you were fighting and she was scratching your neck?
Nope.
She was scratching your neck, her nail broke. Looks like a fight, doesn't it?
No.
Not at all?
Well, it might look like it, but it wasn't.
You said that you had to, in the police interview, you had to drag her out of the car. Do you remember that?
I do remember that.
You also said that she rolled out at first, but you put her back in. Do you remember that?
Yes, I do.
You said that the door kept closing. Do you remember that?
Yes, I do.
If you're standing between the passenger door and the car when it's open, you'd be facing Barbara on the seat. The door would be behind you, right?
Beside me, yes.
Wouldn't it just be easy to just keep the door on your back, hold it open, and attend to Barb?
A lot of things would have been easy.
Well, that would have been easy, right?
I can't say that.
Well, you could keep the door open pretty easily with your behind, right? Right?
You could, yes.
And you said she first rolled out, but you had to put her back in to get the pipe out of the way, right?
Yes.
How was the pipe in the way?
I don't remember how it was in the way. It was hanging in the way.
In the way of what? What was in the way of?
The pipe was hanging through the windshield.
Yeah?
Down past by the seat.
Yeah? What was in the way of?
Getting Barb out of the car.
Okay. The pipe wasn't lodged in the windshield solid, was it? It was loose?
Yes.
You could just take that pipe and just slide it back out from the inside and attend to Barb, right?
In a perfect world, yes.
Well, in any world, right? In this world.
Objection argumentative.
Sustained. Why wouldn't it be easy in this world to slide the pipe out and attend to her?
I wasn't thinking that.
Well,
I don't know. I mean, the door wouldn't stay open, and I was trying to contend with her, and
she was unconscious?
At that point, yes.
It wouldn't have been easy to just pick her up and move her out, would it?
It wasn't, no.
Why wasn't it easy?
Because something was caught on her.
What was caught on her?
I don't know what it was.
Well, there wasn't anything down by her feet, was there?
Something down there was caught on her, yes.
The only thing in the photos is her shoe.
Okay.
Well, what would have been caught on her then?
I don't, something was caught on her.
For speculation. Asked and answered. Overruled.
You don't know?
I don't know.
One of her shoes was left in the vehicle, and the other shoe was behind you, next to the car, right?
Yes.
Were they kicked off in a struggle outside the car?
No.
Did it look like scuff marks from a shoe on the side of the car to you?
I didn't see it.
You saw the pictures?
Yes, I did.
Did you throw one shoe back in the car and couldn't find the other shoe because it was so far behind you?
No.
Well, you didn't drag her out over that seat, did you? The passenger seat? Did you pick her up or drag her out?
I kind of pulled her out.
Pulled her out? You saw the dirt on the side of the passenger seat, right?
Yes.
Didn't look disturbed, did it?
No.
Now, you said to the police that a pipe came off the truck. Do you remember that?
I did say that, yes.
You said it a number of times, didn't you?
I did, yes.
You actually said that you saw it as it came off the truck, right?
I did one time, yes.
You said it rolled off the truck, right?
I thought so, yes.
Now, today you said you didn't know what it was until after it hit the car, right?
I just talked to her and held her hand and gave her a kiss. And
when you talked to her, what did you say?
I told her that I loved her too, and I'd always take care of her mom.
You said, I love you too?
Yes.
Why did you say I love you too?
Because Barbara and I knew each other so well that we didn't say I love you and I love you because we always said it together, so it was always a love you too. And whenever we'd text or something, that was always what it was.
Did you go home that evening?
No, I did not.
Why didn't you go?
I didn't want to go home without Barb there.
Where did you go?
I went to my mom's house.
Did you go home the next day?
No.
Where did you go?
My mom's house again.
On that first night you spent at your mom's house, did you sleep?
No.
On the next night at your mom's house, did you sleep?
No.
On the following day, did you go home?
Yes.
On the following day, when you were at home, did you have people around you?
Yes.
Who was there for you?
It was Jessica, Jordan, Michael, Carlin, Amanda, Lori, my mom. I can't remember who else. There's a whole bunch of people there.
On that next night, did you sleep?
If I did, it was very little.
After her death and before the funeral, did you ever go back to the site where this occurred?
Yes.
Did you go there alone?
No.
With whom did you go?
Amanda, Michael, Jess, and Jordan.
And what was your purpose in going there?
We got a basket, a wicker basket with some flowers in it. And we just took it over there.
And did you leave it there?
Yes, we did. We wrote a little thing on it and left it on the roadside.
The funeral was to be held on Friday?
Yes.
On Thursday, how much sleep had you had?
I don't know, not much.
On Tuesday and Wednesday, I believe you said you had family around. Is that correct?
Yes.
On Thursday, did you leave the home?
Yes, I did.
Why did you leave the home?
I got up in the morning. I went down to a friend of mine's shop. He's got a bunch of woodworking tools there, and we did a bunch of woodworking. And I wanted to make a craft for the funeral.
And what was the craft you wanted to make?
It was a 3-foot by 4-foot pine heart. I glued all the boards together, and I cut a big heart out of it. And I painted it black and distressed it like her hutch at home. I put a bunch of pictures and a poem with her handprint on it.
You said like her hutch at home?
I made her a big hutch at home. She found her up to Cranfest one year and asked if I could make her one, so I made one for her.
So this is a photograph of Mrs. Kendhammer's face, and specifically a close-up on her lower lip. Her eyes would be right up here, and you can see some of that hemorrhaging around the eyes that's on the corner of the photo. This is just a ruler and a label with the case number from the case. And then this is showing the inside surface of the lower lip. And you can see this large area of hemorrhaging or bruising of the tissues of the lower lip.
What's previously been marked as Exhibit 63, can you describe that to us?
Sure, this is, again, a similar picture, only this time we're focusing on the upper lip. And you can see this large area of purple, red bruising or contusion on the inside surface of the upper lip. Other things you can note in here, again, is you see the hemorrhaging around the eyes, and then there is that abraded contusion kind of between the brows there as well.
Looking at the injuries to Barbara's mouth and lips, were there any injuries that you noted on the outside of her lips?
There were no significant external injuries. The injuries were really on the inside of the lips.
Were her teeth damaged at all?
I did not see any evidence of injury or fracture to the teeth, no.
Did you see any injuries to the lips that had a curved or linear pattern, like you'd find at the end of a pipe?
No, I did not.
Could these injuries be caused from flailing?
Well, these injuries are blunt impact injuries. So what that means is that a blunt object either struck the mouth or the mouth hit into a blunt object. I can't tell you definitively how that happened. Theoretically, it could be possible from failing to strike your face into a blunt object, but I would think it would have to be pretty forceful to generate this amount of bruising on the inside of the lips.
Thank you. Now showing you what's been previously marked as Exhibit 64. Can you tell us what's depicted in that photo?
Sure. So this is a photograph. This is actually after autopsy was complete. We can see that there is a bruise on the right jawline and extending onto the right neck. So we see that red-purple bruising there. You can faintly see some abrasions on the neck and some abrasions down here, but I think you'll see them better in a different photograph.
Can you tell us what causes a contusion?
Again, a contusion, much like an abrasion or a laceration, they're all different forms of blunt impact injuries. So when something either strikes the skin or the skin is pushed up against a blunt surface, it causes damage to the blood vessels in the skin, and that causes cells to leak out and give that appearance of hemorrhaging into the skin.
Thank you. Showing you what's previously marked as Exhibit 65. Can you tell us what this photo is?
This is a photograph of Mrs. Kendhammer's forehead, and you can see her eyebrows right here. We can see this abraded contusion between the brows there. And then this is the sutured laceration that was on the midpart of her forehead.
Did you put those sutures in?
I did not, no.
Did you at any point take the sutures out?
I did.
And why did you do that?
I took the sutures out to see the margins of the wound better, because when it's sutured together, I can't really see it too well, and to see how far the laceration went, and it was a full thickness laceration of the skin of the forehead.
During interrogation, officers listen to the suspect's words and observe their gestures and mannerisms. However, distinguishing between truth and falsehood can sometimes be challenging.
I tried to hold on to the way I think with my right hand, and lunge hard with my left, but I think I ended up going with both hands, because when I turned on the road, I was over, I don't think I was in I think I was more in her side of the seat than my side of the seat. And I don't, from then, I mean, I think, I don't know for sure, but I think I didn't know that she was hurt bad at first. And I don't remember, I remember seeing her, realizing that what was going on,
When you first realized what was going on, what was it that you were realizing?
That she didn't say nothing at all.
Mm-hmm.
She didn't say nothing at all. And she thrashed. She was like thrashing a couple, 2 or 3 times, I think. I don't know if she did it more than that or not.
Okay.
And
where was the pipe when she was doing that?
Sticking through she was trying to get, I think she was trying to get away from the pipe.
Okay.
I think.
Do you recall, was it on the left side, right side?
I don't know. I don't remember.
Right.
And I was trying to, I don't know how or why I put the car in reverse. But I put the car in reverse, and I got out to stop. I tried to stop. And I ended up, I put it in reverse somehow. I don't know what happened or how. And I don't remember. I don't know in the back of the car, I think. And I didn't lift her out. I don't think I lifted her out of the car. I said, easy. I think
How did you get her out of the car?
I think I just yanked her out of the car.
Okay. When you say yank, I don't know what that means to you, or it doesn't, you know.
I don't know for sure how I got her out of the car.
Okay.
I don't think I just lifted her nicely, no.
Okay. What do you think that you did?
I don't know. I don't want to say. I don't know.
Okay.
I think
What makes you think that you didn't take her out nicely?
Because I needed to get her. I needed to get her out and help her.
Mm-hmm.
And I was on the bank. I couldn't stand up. I was up on the bank a little bit. It was all wet and mud. And I got her out of the car. I tried to get her head facing up the hill. I thought I was CPR. I tried to clean her up a little bit quick before I did anything. And
what clean her up a bit? What is
I just took my shirt.
Okay.
And she was bleeding her nose and her mouth and her ears. And I didn't think at first to call. I didn't think my phone. I didn't think of anything. I had trouble when I tried to, and I don't know for sure, but I think I had trouble with that pipe trying to get her out of the car, and that's why I ended up just yanking her out of the car and throwing the pipe.
Okay. Did you get her out of the car?
I got her out. I did CPR on her.
Okay. And then you got the pipe, or you had to take the pipe out first and then
I don't know for sure. I can't say. I think
Once you got out of the car, did you leave her side? You did CPR.
I never left her side. I started CPR, and then she was bleeding so bad. That's when I called the dispatch.
No matter what, a mother will never see her child as a criminal. She'll always try to protect them, seeing them as innocent. Similarly, no one wants to believe that their relative is a criminal.
You'd state your name and spell your last name.
My name is Patricia Kendhammer, Kendhammer.
What would you like to say today?
I am Todd's mother. I am in touch with Todd and have been able to observe Todd and his family over the years. What I have seen is a good husband who cared deeply for his wife, a good father who was interested and involved in the lives of his children, Jessica and Jordan, a man who loves his family, a man who helps others, who will come over to help me anytime for anything. This is why we'll all support Todd. This is why we will continue to support Todd and hope that we will be able to return him home at some point in time in the future. Thank you.
Thank you.
Thank you. David Adams, Judge.
State your name and spell your last name.
David Adams, A-D-A-M-S.
What would you like to say today, Mr. Adams?
I'm David Adams, Todd's brother-in-law, Barbara's brother. And I'd like to say that Todd is a kind, caring man who I have never seen behave poorly or in a controlling manner toward anyone. And I would like to ask you to allow Todd to be able to ask for parole after 20 years. I ask of this for myself and my mother, who was unable to attend today. Thank you.
Thank you. We, the jury, find the defendant, Todd A. Kendhammer, guilty of first-degree intentional homicide as charged in the information. In the other reading, we, the jury, find the defendant, Todd A. Kendhammer, not guilty of first-degree intentional homicide as charged in the information. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberation. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. Right, in a few minutes, I'm going to ask the jury to come in. I expect absolutely no comments in any way, shape, or form from any member of this courtroom at this time. Anyone that does so will be disrespectful to the jury, first of all. And second of all, the deputies have been directed to take out individuals that may pose a problem. And that doesn't matter which way the verdict is. So we'll see what happens. The jury's ready, bring them in. All right, ladies and gentlemen, it's my understanding you've reached a verdict, is that correct?
Yes, Your Honor.
And you reduced it to the verdict form you believe correctly?
Yes, sir.
You can give that to the bailiff and everyone may be seated. Mr. Kendhammer, if you'd please rise for the reading of the verdict. State of Wisconsin versus Todd A. Kendhammer, 16 CF 909. We, the jury, find the defendant, Todd A. Kendhammer, guilty of first-degree intentional homicide as charged in the information. Dated this 14th day of December, 2017. Signed Timothy, foreperson. You may be seated. Ladies and gentlemen, the verdict I just read this is the verdict of each of you. Would you please raise your right hand? I see all 12 jurors have raised their right hand. Thank you. Mr. Grinke, do you wish the jury polled?
No.
Mr. Hurley?
Yes.
All right, ladies and gentlemen, at this point I will ask each of you individually by pointing at you what your verdict was, and then you can put that on the record. We'll start with you, Timothy.
Guilty.
You?
Guilty. 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 Guilty.
All right, all 12 jurors have responded guilty. Anything further from the defense? Ladies and gentlemen, at this time, your service to the county is completed. There's several things I need to talk to you about. Once you are in the jury room, I'll be there momentarily. You are now discharged. There's no further requirement of secrecy. You may talk to anyone you wish about this case, and you don't have to talk to anybody at all if you do not want to. And I'll see you in a few minutes. The record could show we're now outside the presence of the jury. Mr. Grinke, any further comments?
No, Your Honor, we're going to ask that his bond be revoked pending sentencing.
Mr. Hurley, anything further?
Not at this time.
Okay. Well, the court, having heard the testimony, will accept the jury's verdict. I'll enter a judgment of conviction on behalf of Mr. Kendhammer on count 1, first-degree intentional homicide, contrary to Wisconsin statute section 940.01, parent 1, parent A, and 939.50, parent 3, parent A. I will revoke your bond. You'll be remanded to the custody of the sheriff. I'll set sentencing for March 9th, starting at 9 o'clock. I'll ask that any PSI be submitted to the court no later than the 1st of March. We're adjourned.
How do you keep your head up? All right, Dad, we'll get you out. Don't worry about it.
And that's one of the factors, as pointed out, that would go against you being released. I agree with Mr. Grinke. If you were to come to the court and say, you know, I've gone through prison counseling, I've come to agree that this is in fact what I did, I've done some rehabilitation, at that point maybe you could be released. I would also wonder whether there would be that supportive family that believes in you so much and finds out that you maybe are lying to them. They may not be there at that point if that's what happens, but we don't know. I'll go through some of these factors. I agree you have no prior record. There were some issues surrounding some employment issues. You may contest those. It was set forth in the PSI. Some is old. Your personality seems to show some sort of obsessiveness with how people think of you. That goes back to some of these old events that Ms. Winch uncovered, and how she thought you were selling yourself to her, how I saw you selling yourself to the jury and to law enforcement during the interviews. You want people to think well of you. There's nothing wrong with that per se. Some of the behaviors you do, going out and helping people, dropping everything to go help people, show some altruistic behaviors, but again, it can go to you wanting to look good to people, which can become an issue. How did your wife look at you at some point before this? Is that a precipitating factor to this end of her life? Nobody will know but you and her, and she can't speak. The vicious or aggravated nature of the crime speaks for itself. There's nothing much more I can say about that. To me, you snapped on that date, you lost it, committed this horrific act. Barbara's dead. And there's the cover-up thereafter. That goes to your degree of culpability. You are the one responsible for her death. That's some pipe falling off a truck. You're 47 right now? Okay. Apparently you're appropriately educated to be where you are in life at this time. You've basically had steady employment. Those are all factors in your favor. Looking at your remorse or repentance or cooperativeness, you deny the crime. You have the right to do that. Once the appeals are done, I don't know what's going to happen at that point. Just indicate that counsel for both sides did an exemplary job of presenting this case. I was actually quite surprised based on all the stipulations to the evidence coming in. Very few objections. I really don't see any issues that would be appealable in this case, but you have the right to pursue that. But once the appeal is done, then you'll be sitting there for whatever length of time to try to remedy this in your mind, in the minds of all your supporters, and in the minds of the truth. I agree the evidence was overwhelming. Your attorneys presented significant evidence. The glass expert, the jury didn't believe. The person on the mechanics, they didn't believe. The doctor, sorry, the state couldn't get the main injury straight, but accepted the evidence that the state put in. In this case here, you had a marriage of 25 years. Your attorney's asking for a 20-year parole eligibility date. I don't know if you're going to be able to tell the judge that reviews that release request whenever it happens that you've come to grips, you've amended the situation. Because if you don't do that, I doubt that any judge would ever release you. 20 years is way too short. The length of your marriage at 25 years is, in my mind, way too short. I will set your parole eligibility or review date at March 9th of 2048, 30 years from now, when you're 77. I think that would be somewhat consistent with a crime of passion, a second-degree homicide, had you not put the police down the path you took them. But if you don't correct that by then, in 30 years, the judge denies it, that life sentence will be that. So I hope you understand this. So I will prepare the written explanation of determinant sentence. Your total length of your sentence for count 1 is life imprisonment. You are eligible for release to extended supervision after serving 30 years and 0 months. This document will give you further information on how you can extend that date by bad behavior. I'm not sure that prior sentence credit is really going to have much to do with that, since the date starts 30 years from today. Can you comment on that, Mr. Bernard?
I don't know the answer to that question, Judge, but I can certainly follow up with written communication. I don't know if you get credit for time served on the parole eligibility determination date.
Since I picked a specific day, I don't know that he gets any additional credit. Mr. Grinke, any comment on that?
That would be my understanding.
If I'm wrong on that, you can let me know. It would not be the first time I correct a judgment of conviction. Now, Mr. Kendhammer, as I alluded to earlier, you do have the right to appeal my sentence. Talk to your attorneys. I'm sure they'll be capable of going forward on that for you. There's a lot you need to accomplish over the next 30 years. And I hope that you can do that. Try to give some meaning to the people that are disappointed in you. See if you still have the supporters behind you if you come out of this differently. Wish you well. Anything else, Mr. Grinke?
Just that, Your Honor, if we are wrong about the credit, I agree with 95 days credit today.
95?
Yes.
Okay. Is that what you had on your report?
That's what we calculated, yes.
Yep, 95. Just put that in the minutes so I can see it quicker than looking through all the documents. Anything else from you, Mr. Bernard?
No.
Mr. Kendhammer? Good luck.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.